to pay rent, and they're entitled to essentially a deferment of their rent while this emergency order or this pandemic is in place. Now, in order for you to get the benefits under the Newsom order, you have to notify your landlord within 7 days after rent becomes due, and it has to be in writing. Okay, so for instance, for April 1st rent, you would have 7 days after the 1st, if your rent is due on the 1st, to notify your landlord in writing that you're unable to pay rent. And you as the tenant are responsible for maintaining certain documentation to show that your inability to pay rent is due to a COVID-19 related circumstance. And there are 3 circumstances that are identified in Governor Newsom's order. Okay, the first is you have to have been current on your rent prior to the order. So if, for instance, you were already behind in January, February, you're not going to be able to then tell your landlord, oh, I can't pay the rent because of COVID-19, because in January and February, there was no emergency order in place. So you have to, 1, prove that you were current on the rent prior to the date of the order. And the order went into effect in March. I'll get the exact date. And so if it's prior to the date of the order, the protections are not going to be available to you. The second thing is you're going to have to show that your loss of income was caused by a COVID-19 related circumstance. So whether you lost your job, so you have documentation of loss of employment, if you have proof that you yourself or a member of your household, for instance, was affected by COVID because you became ill, and you have medical expenses related to the virus, then that would be considered a COVID-19 circumstance. The information has to be verifiable, meaning you have to have something in writing, whether it's from an employer. I would imagine if you've applied for unemployment, for instance, you would be able to use documentation of, for instance, your award letter that you're receiving unemployment after the date of the order, to show that you have verifiable documentation that your loss of income was related to COVID-19. Also under Governor Newsom's order, the Sheriff's Department is prohibited from executing a writ of possession. So for instance, when you get evicted, the sheriff is the one that comes and does the lockout or comes out to assist the landlord with regaining possession of the property. Under Governor Newsom's order, the sheriff cannot execute the writ of possession that would allow your landlord to regain possession. And so that effectively removes or eliminates a landlord's ability to enforce any kind of eviction efforts under this moratorium. Again, you've got to be able to show, though, that you, 1, were current on your rent prior to the date of the order, that the loss of income that you incurred was caused by COVID-19, and you have to have verifiable documentation. So Governor Newsom's order applies statewide. It doesn't matter what county, what city you're in throughout California. The tenants have protections under this moratorium pursuant to Governor Newsom. Now, the second order that's in place that affects everyone statewide, regardless of where you are in California, is the Judicial Council order that was issued on April 6th. Now, the Judicial Council is the governing body that oversees the courts within the state of California. And so on April 6th, they issued an order, which was one of 11 temporary orders, which basically says that the courts will not process a summons on an unlawful detainer case until 90 days after the emergency order issued by Governor Newsom is lifted. So what that means essentially is that your landlord could serve you with an eviction notice. They could go as far as filing an unlawful detainer complaint or eviction complaint. However, the clerk of courts, which issues the summons on those complaints, will not issue a summons. And so your landlord will not be able to serve you with any eviction complaint until 90 days after the emergency order is lifted. Now, as of right now, Governor Newsom's order is set to terminate on May 31st. The laws are changing daily. As many of you may have heard, the stay-at-home order for Los Angeles County was extended to May 15th. So it's very likely that the emergency order may extend beyond May 31st. At this point, we don't know. But under this judicial council order, 90 days after May 31st, which takes us to the end of August, the clerk of courts will not process a summons on any eviction complaint. Under the judicial council order, the judge also ordered the courts to set aside or void any default judgments that were entered and in an eviction case. So if you were served with an eviction case, say prior to this April 6th order in, let's say, March of this year, and you have not yet appeared in the case or you have not yet answered, the April 6th order issued by the Judicial Council will allow for essentially you to have more time before you have to answer that complaint. So that's another protection under this Judicial Council order. And again, this extends throughout the state of California. So in conjunction with Governor Newsom's order, not only are you as a tenant entitled to a deferment if you notify your landlord within 7 days in writing, and you maintain your documentation that you have a COVID-19 related circumstance preventing you from paying your rent, the Judicial Council order effectively allows you to rest at ease, if you will, that your landlord will not be able to still file an eviction complaint against you and enforce that complaint during the time that the emergency order is in place. Now, in addition to those two areas of law that are offering protections, you have the ordinance that was issued by Mayor Garcetti on March 27th. Again, this ordinance affects the rental properties that are in the city of Los Angeles. So if your property is outside of Los Angeles in, again, Burbank, Glendale, Santa Clarita, West Hollywood, any of those surrounding areas, this ordinance does not apply to you. However, there may be a similar ordinance. But I want to get into the specifics because I know many of you are in the city of Los Angeles. So under this city of Los Angeles ordinance, this ordinance effectively prohibits not only at-fault evictions, but also no-fault evictions. So if you are unable to pay your rent, your landlord cannot evict you. If you are on time with your rent, but let's say your landlord wants to attempt to do an eviction during this this pandemic, which would be considered an Ellis Act eviction. So this is where they want to either remove the property from the rental market, they want to demolish the property, or let's say they want to take possession of the property to move in either the owner or someone of the immediate family member. So the landlord is basically wanting to evict you even though you're not in breach of your lease agreement and you haven't done anything wrong per se. That's considered a no-fault eviction. Those evictions are also prohibited under Mayor Garcetti's ordinance. So if your landlord serves you with any kind of eviction notice, whether it is because of a breach of lease, which would be for non-payment, for instance, a noise violation, or if they wanted to serve you with a notice saying, you know, we're going to take the property off the rental market and so you have to be out. Both of those types of evictions are prohibited under the LA ordinance. On March 30th, Mayor Garcetti issued an ordinance which said that rent increases for properties covered under the rent stabilization ordinance is also prohibited until 60 days after the emergency order is lifted. And so your landlord cannot increase your rent during the time of this emergency order being in place. They can't serve you with any notices saying that your rent is going to go up for any amount if your property is covered under the rent stabilization ordinance. Lastly, Your landlord cannot evict you if you have additional occupants or pets because of a COVID-19 related circumstance. So for instance, if you have a loved one or family member who had to move in so that you could care for them, or if you're caring for, a pet because of COVID-19, because as we know, animals can get COVID-19 as well, apparently. Your landlord cannot evict you because you have an additional occupant or you have an additional pet. And so the point and purpose of these laws is to protect all tenants and sort of ease any anxiety or fear that they could potentially become homeless or have to navigate the eviction process while also dealing with this pandemic. And so the provisions under the LA ordinance are very expansive. But again, most cities, local cities have adopted similar laws. You can check with the local area's website. The information is generally published on their website. So for instance, if you were to go to the city of Glendale and look at their COVID-19 related laws, you'll be able to see a copy of the ordinance and see what variations there may be with what I'm discussing here. You should also, however, consult with an attorney. So if you have questions about whether or not your particular area is covered under an eviction moratorium ordinance, we'll have my contact information so that you can inquire about that later. So what happens if you cannot pay your rent? Taking all of these ordinances together, the first thing that you should do is notify your landlord in writing that you are unable to pay your rent. It needs to be, again, within 7 days after your rent is due. And you need to indicate in your writing that you're unable to pay because of a COVID-19 related circumstance. So it's not enough just to write your landlord and say, hey, I'm not going to be able to pay my rent this month, and think that you're going to be entitled to the protections and deferments available under these three areas of law. You need to be specific that either your inability to pay is because of loss of income. So for instance, if you're considered a non-essential employee and your hours were reduced, or your employer has completely shut down or closed for a period of time, that would be considered a valid reason. Another circumstance is if you have increased childcare expenditures. So as we know, the LA County schools are closed, many daycares are closed. So if you have had to incur additional expenditures to care for your children, and you have either an increase of expense related to that in finding alternative childcare, that would be a circumstance that's considered relatable to COVID-19. If you have any healthcare expenditures stemming from COVID-19, whether you yourself are infected, a family member, or a member of your household, and you have expenses related to that, that would be a justifiable reason. And then lastly, any reasonable expenditures stemming from government ordered emergency measures. So that last provision is really kind of broad. One thing that I didn't mention is that these laws apply to both residential and commercial tenants. So if any of you are business owners and you are leasing a commercial property, and let's say, again, you're considered a non-essential business, and so you are required to close your operations until the order is lifted, that would be an expenditure stemming from the government ordered emergency measure. And so your loss of income would be a justifiable reason for you not to pay rent. And so you want to be specific in your writing as to why you're unable to pay, and it needs to fall under one of these four categories. The other thing you need to do is make sure that you have proper documentation. So again, whether that's a letter from your employer, if you have recently applied for unemployment, if you have something from your doctor, Obviously there are privacy laws regarding medical records. And so at this point, there's no requirement that you provide your landlord with, copies of your medical records. But if you are receiving treatment for COVID-19, you could easily get something from your doctor just simply stating that you were diagnosed with COVID-19 and you're receiving treatment, or if you have medical expenses that you can show. You'll want to make sure that you have that documentation and that you maintain it. Now, there's no requirement that you provide your landlord with the documentation at the same time that you notify them you're unable to pay. However, there may be some changes with that. I know there were recently some amendments that are being considered in terms of what documentation you have to have and whether or not your landlord is going to be entitled to request it up front. But let's say, for instance, you have this documentation and your landlord asks for it. There's no reason why you shouldn't, in good faith, provide the documentation that you have. We all know that, everyone's sort of trying to figure out this new normal and adjust. And your landlords are now probably experiencing a lot of the same anxieties that you are. So there's that commonality between all of us, really, because if you, the tenant, aren't paying rent, trust and believe that your landlord's trying to figure out how they're going to pay their mortgage on that property as well. And so hopefully you and your landlord will be able to come together and realize that, look, everyone's anxious, everyone's trying to figure this out. And so in the spirit of full disclosure, if your landlord requests that you provide certain documentation, I would encourage you to do so, as long as it's not, overly invasive. Like I said, if they're, asking for your medical records or something like that. Under the ordinance issued by Mayor Garcetti, if you provide, or if you have the documentation that you qualify under one of the enumerated circumstances, you have up to 12 months to repay your rent. So from the time that you notify your landlord that you're unable to pay, and then 12 months after the emergency order is lifted. So again, as of right now, Governor Newsom's order is set to expire May 31st. If you are in the city of Los Angeles and you're unable to pay your rent, that would effectively mean you have 12 months from May 31st. So going through May of 2021, you would have that time period to repay any unpaid rent. Now, does that mean that you should let that money, let that unpaid rent accumulate for the next year if you are in fact able to pay something? And the answer to that is no, because what's going to happen May of 2021, you're going to have a bill of close to $20,000 or more that you're going to owe your landlord. And unless something changes in the law between now and then, your landlord is going to be able to give you a 3-day notice that says you have 3 days to pay $20,000+. And if you don't, they can immediately start an eviction against you. And so the law does not require that you come up with a payment arrangement with your landlord. However, I would absolutely recommend that you do so. So if you are unable to pay the full rent because of loss of income or any of the other circumstances, there's nothing preventing you from offering or suggesting a payment plan to your landlord. So, if you can pay $200 to $500 on your rent each month, I would absolutely encourage you to do so. I would encourage you to come up with a payment plan that is feasible. If you have experienced a loss of income, again, it's completely voluntary between you and your landlord. And so you don't want to offer or suggest a payment plan that's going to be, the same amount of rent that you were paying or even close to it if you're not sure what your financial circumstance is going to look like. But again, there's nothing preventing you from, say, agreeing to pay $200 to $500 towards your rent each month as part of a payment plan. In fact, your landlord may request, if you do offer to do a payment plan, they may offer that you put it in writing and make that agreement a part of your lease as essentially an addendum. So basically, if you do a payment plan with your landlord that you're going to pay a certain amount each month, the landlord can make that a part of your lease agreement. And so if you don't pay the amount that was agreed upon, then essentially you could be considered in breach of your lease agreement. So while it's necessary for you to sort of set aside any monies that you can towards your rent, so that you don't have this large bill, you want to use caution when entering into any kind of payment agreement that's in writing, if you're not going to be able to make that payment, because again, it could give your landlord another grounds for an eviction if, for instance, you were to breach that payment arrangement. So residential tenants, you have up to 12 months to repay any unpaid rent. Commercial tenants, you will have up to 3 months after the emergency period expires. So again, if we're looking at May 31st as our benchmark date for commercial tenants, that would be June, July, August. 3 months after the May date would take you to August that you would have to repay. If you're unable to pay, your landlord cannot charge you late fees. They cannot charge you interest. So if your landlord says, okay, I'm accepting your documentation that you're unable to pay, but I'm going to charge you late fees, for that year, they cannot do that. They can't charge you interest on those fees, and they cannot in any way otherwise retaliate against you because you are exercising your right under these protections. So the main thing is, one, notifying your landlord in writing, making sure that you maintain your documentation, that you have a COVID-19 related circumstance. And then if you're able to do any kind of payment plan, you'll want to make sure that you can set some funds aside, even if it's just a little bit. If your landlord asks you to put that payment plan in writing, make sure that it's an amount that's feasible to you, and is going to give you some wiggle room in case your financial circumstances change. And as we know, things are changing again almost every day. I will note that these 3 areas of laws that I just went over, are current as of today. And so it's quite possible that tomorrow there may be some amendment or some change or some additional protection. But these are the 3 areas of law that you can rely on as of now in the event that you have any issues with paying your rent, or if there's any question with whether or not you can be evicted during this time. I've actually received several calls within the last week from tenants who have received eviction notices. And these notices are purely just to terminate the lease agreement. And I don't know I do know, again, landlords are scared too. I have a lot of clients who are property owners, and many of them are concerned about how they're going to pay for their own residence as well as the mortgages on their rental properties. And so in response to that anxiety and fear, there may be a lot of landlords who are trying to just sort of get out any problem tenants or any tenants who they may feel may not be unable to pay the rent. And so they may just, start handing out eviction notices. Under that judicial council order that I mentioned, even if you are outside of the city of LA, and so you're not entitled to those Mayor Garcetti protections that I went over, no court in California is permitted to process an eviction, period. Until that order is lifted, your landlord cannot serve you with an eviction complaint. Your landlord cannot go into court without your notice and get a default judgment against you. And the sheriff's office cannot execute or enforce any writ of possession to remove you from the property until 90 days after this ordinance, this emergency order is lifted. Now, there is a small exception under the judicial council order which allows for an eviction if it's necessary for public health or safety. So for instance, if there's a tenant that is being violent, or a tenant that is creating a nuisance such that it affects or impacts public safety, then your landlord could go in and seek an emergency eviction. But it would be up to the judge and under the judge's discretion to determine whether or not it is in fact an emergency. So there is a small exception, but outside of that circumstance, there are no evictions that are going to be taking place within the next 30 days, next 90 days, depending on, again, where you're located. Now, as I mentioned, there is, for instance, in the Burbank area, the moratorium ends at the end of April. And so unless Burbank, for instance, extends that moratorium, landlords there could start issuing eviction notices. But again, under the court order, they're not going to be processed. So it can definitely get a little confusing when you're looking at the interplay of all of these three laws together. But for your assurance, just know that at least until 90 days after May 31st, the court is not going to process any evictions. If you do have an issue with your landlord where you receive an eviction notice or you receive anything threatening to file an eviction, you should certainly consult an attorney to make sure that no action is taken against you that is prohibited under any of these laws. So hopefully you all were taking notes. I know that's a lot of information to digest. I think we should just jump right into the questions now, though, because I'm sure there may be some questions that many of you have had before or that have come up based on the information that you've received today. So I'll turn it over to Marissa for her to filter in some of those questions.
Okay, so I know that there was a question in the chat box. I did take quite some pretty detailed notes in the chat box, you guys. So when you guys get the replay, which will be sent to you all by email because you signed up through our website to join this conversation, you will have access to the notes. It will show on the replay as well. But one question was, is this applicable only in California? So I know that Tiffany was specifically addressing the rules and the laws that are related to California and the Los Angeles area, because that's where she practices and that's where we're primarily based. But I did, and I'm not sure if you did as well, Tiffany, but I did a lot of thorough research, and I actually, it's pretty much across the board. The dates of the orders are different. The time frames are different and things like that for each state. Each state has their own ordinances, each city, some counties. It really is just going to depend on where you live. But essentially what I found, and you can correct me if I'm wrong, Tiff, what I found is that pretty much every state has some kind of relief set up, specifically if it's a state that has the stay-at-home orders that are in place. And even in some states that don't necessarily have that, just because of the fact that a national emergency was declared, I was able to find, some kind of relief or some type of ordinance or laws that were put in place in each state. And I literally went through all of the states. So one thing that I did, just for everyone to have a resource after this is over, if there is someone on here who's not in California, I am putting together a resource guide that will have links to the information for each state that you can find out the specifics as it relates to the details for your particular state. But so those of you who signed up, which are all here on the Zoom chat, when you get the replay, you'll also have, I will also send that resource as well. Tiffany, did you have anything to add?
Yeah, most states have some sort of eviction moratorium. Because I don't practice throughout the country, I didn't research all of those, but you should definitely check within your particular state and city to find out what protections you have. But in almost every state, there's some sort of moratorium in place to protect against any kind of evictions and foreclosures as well. That's something else that I will mention, is that if there is an eviction related to a foreclosure, for instance, if you're renting a property and that property was sold at a foreclosure and the new owners are now wanting to remove you as the tenant from that property, those types of evictions are prohibited as well. So it applies to not just non-payment of rent issues between, say, you and your landlord, the current owner, but any new owners that would try to come in and remove tenants from the property pursuant to a trustee sale. And again, this is all specific to California.
Shannon has a question. Shannon, you can unmute yourself.
So not really a question, but just because I know that we probably have people on that are from different states. And I know in Florida, at least in Orange County, what Orange County sheriffs have done is, because even there are cases that have continue to move forward. I'm actually dealing with an unlawful detainer case right now that is still moving forward. However, if they get a final judgment, the sheriff is not serving the writ. And then, like you said, as far as the summons, though the summonses are still being issued in Orange County, in the event that they are issued, they're not being served. The only thing right now that's being served in Orange County are emergent sort of matters, such as injunctions, domestic violence injunctions. But with regards to evictions and unlawful detainers and even foreclosures, we're not getting any of those summonses served by the sheriff or by private process servers.
That's a good point. If you are a tenant and let's say you were involved in an unlawful detainer that was already filed, served, let's say you already had a court date, pursuant to the orders that were issued by the presiding judge of the LA Superior Courts, for instance, any cases that were set to go to trial have been rescheduled for 60 days. So if you had a trial scheduled for April, that's automatically getting pushed out. I know several of my clients who had evictions already pending have now received new trial dates for sometime in July of this year. So currently, everything is pretty much at a standstill in terms of evictions, whether it's cases that were pending or the processing of any new complaints.
Awesome. I know that there was a comment in the chat box related to Illinois. I did do some research on Illinois as well. And like I said, I'm going to send a link that has the resource information for you to pull all the exact details. And so you can reach out to an attorney in Illinois, specifically, but I know that Illinois does have some relief measures as well. They have some funding that has been, I think they're dispersing it if they haven't already. And they have grants available for rent and mortgage payments of Chicago residents. Not sure if that's where you are. They also have a moratorium on evictions, foreclosures, and utility shutoffs, and rental assistance programs for those who are in immediate jeopardy of being evicted. So like I said, most of the states across the board have something in place. You just have to be able to obviously find out what it is and take action. But one of the most important things that I think that Tiffany talked about was the importance of communication and making sure that you submit your notice in writing to your landlord. And I think this is going to apply regardless of where you are. You need to submit your notice in writing. Don't just not pay and then, expect that everything's going to go your way, because it doesn't really work like that. So I think that that's something that's really important for everyone to do. And then also the point about making sure that you have your documentation, whatever that looks like, to make sure that you can show that you legitimately could not pay your rent or your mortgage. Also, since we segued into at least having a brief conversation about mortgages, if you do have a mortgage and you have not already, checked with your lender, I know I haven't been able to find any major lenders that haven't put something in place as well, whether it be a temporary deferment or, postponing your mortgage for a few months or refinancing or whatever the case may be. So just make sure you look into that. But the key is going to be just researching, knowing what the laws are in your state and city or county, however it applies to you, and then just making sure that you take the steps to make sure that you don't just ignore the fact that your rent is due or your mortgage is due and not paying it. Does anyone else have any questions? I don't see any more in the chat box. Does anybody else have any questions? You want to unmute your mics? And thank you, Shannon, for chiming in. Shannon is one of our lead attorneys in our Florida division of the collective. Anybody else? Any questions? Any comments? Okay, someone has a question. Okay, what's your question?
Okay, so hey Tiffany, Nicole here. I'm feeling sick this morning, so I'm not gonna get on camera. But my question, hey, quiet, out of here. Sorry, children. My question is, can you just repeat? You said that these ordinances and these protections also extend to business owners, right? Who have to shut their doors.
Absolutely. So it applies to not just residential tenants, but commercial tenants as well. So if you are a business owner and you're renting or leasing a commercial property in the city of Los Angeles, the landlord cannot evict you for non-payment of rent because of a COVID-related circumstance. The time period that you have to repay the rent is shorter. As I mentioned, residential tenants have up to 12 months. Commercial tenants have only up to 3 months after the emergency order is lifted. But nonetheless, you should definitely take advantage of that if you find yourself in a circumstance where you are unable to pay. There may be, as a business owner, there may be other relief options that you have outside of just this ordinance. And we will be doing another collective talk on contract provisions that you may be able to use to your advantage if you're a business owner. For instance, there may be force majeure provisions that would allow you to get out of a lease agreement, for instance. There may be early termination provisions in your lease that may offer you some relief as a commercial tenant. But to answer your question, yes, these provisions apply to both residential and commercial. Now, if you're leasing a commercial property outside of the city of LA, again, you'll want to check with the local area to determine, one, whether those local ordinances apply to commercial properties, because not all of the local ordinances that have been issued apply to commercial properties in the same way that they have been within the city of LA. So that's something that you'll want to check on to make sure that you're protected in terms of a local eviction. The courts, however, as I mentioned, are not processing any evictions, period. So even if the local area does not prevent your landlord from serving you with an eviction notice and going as far as filing an unlawful detainer, they're not going to be able to do anything with it.
Okay. Thank you so much.
Awesome. Anyone else have any questions, comments? Going once? Nothing? Okay. Well, thank you all for tuning in. Thank you so much, Tiffany, for this valuable information. I hope you all found this conversation helpful. You can find Tiffany on Instagram at Trav Law Firm. That's TRAV as in Victor, Law, LAW, Firm, FIRM. And of course, you can find the rest of us, including Tiffany, at The Collective Legal on Instagram. We're also on Facebook. Tomorrow, we will be hosting a collective conversation on child custody and co-parenting during quarantine. So if you or anyone you know needs that information, please share and let them know that that's what's going to be going on. Anyone can sign up for our collective conversations on our website, www.thecollectivelcm for legal and crisis management.com/events. So again, thank you all for tuning in. We will submit the replay to you as well as the resource guide that I am putting together with the links and information for each state. And I did see a comment come through really quick. Let me see. Oh, those are Shannon's notes. Okay. So thank you all for tuning in, and we will see you next time.
Thank you, everyone. Have a good day.